If my parent owns property in more than one state, what happens with probate, and how can we avoid having to open probate in multiple places? In most cases, probate starts in the state where your parent lived at death, and then you also need an additional court process in each other state where your parent owned real estate in their individual name. That extra case is often called ancillary probate or ancillary administration. The reason is simple. Real estate is usually controlled by the law of the state where the land is located, and the local court process is what allows title to be transferred and the land records to be updated. If your parent owned a property solely in their name, the personal representative usually has to open a local estate file, get authority to act, and then record the right documents in the county land records. To avoid multiple probates, planning usually focuses on changing how the out-of-state real estate is titled before death so it passes outside probate. Common options include putting the property into a properly funded revocable living trust or using ownership with a right of survivorship when it fits the situation. Be careful, though. Just being on the deed is not always enough if the deed does not clearly create survivorship ownership, and adding a child to title during life can create creditor, control, and family dispute problems. The best approach depends on the type of property and the family's goals, but the key idea is this. If the property is set up to transfer automatically at death, you can often avoid having to open probate in multiple places.